A very good morning to all my dear students. Today we are going to discuss about a new topic, and the said topic is on WS, or in other words written statement. As you all are aware that till date we have already done with the following topics, and these are introductory part about the CPC. Thereafter, we have dealt with the definition part as contemplated under the Code of Civil Procedure, and thereafter we have dealt with the the jurisdiction aspect given under the Code of Civil Procedure. Thereafter, we have also dealt with the meaning and concept behind pleadings. As you all know about the pleadings, the word pleadings has been defined under Order 6 Rule 1 CPC, whereby it includes plaint or written statement. Furthermore, we had also discussed in the last lecture about the concept of plaint. In today's lecture, I am going to explain you about the concept of written statement. Now, let's start with the same. Hope you will learn a lot from it. The word written statement has not been defined in the code. Here, the word code means the code of civil procedure. Furthermore, the as you all are aware that the definition clause is given under section 2 clause 1 of the section 2 of the CPC, wherein various expressions have been defined. But legislature did not take steps to define the concept of written statement therein. As such, now we are going to explain it by way of the judicial interpretation given by various jurists, or we may look into the dictionary meaning as given under various legal dictionaries. Written statement is the reply by the defendant to the plaint filed by the plaintiff. Meaning thereby, under this, the defendant has been given an opportunity to file its reply, thereby fulfilling the requirements of principles of natural justice, and also to satisfy the doctrine laid down under the admin law or the constitutional law, which is based upon equity law as well. And that doctrine is odi alteram partem, meaning thereby right to be heard. Furthermore, now, is there any time limit for filing the WS? Yes, by virtue of 2002 Amendment Act, the time limit has been given as 30 days, and this 30 days needs to be computed or calculated from the date of the service of the summons on the defendant. Now, is this period can further be extended by the court of law in certain circumstances? The answer is yes. Under Order 8, Rule 1 of the Code of Civil Procedure, this time period can further be extended by 90 days or up to 90 days. Now, a question must arise in the mind of a law student over here is that whether or what would be the position in case this period of 90 days has also been expired and defendant till this date fails to file his written statement, then what would be its remedy? The remedy for the defendant in that particular case, then he may file an application under section 148 of the civil procedure, wherein the court has been empowered to extend the period for a further period of 30 days. Now, the second question, which must be raised by a law student at this point of time, is that what would be the position after this 30 days period is also expired? Whether the defendant can also have another remedy? The answer is yes. After the expiry of this limitation period, the defendant can file an application under section 5 of the Limitation Act, wherein on sufficient reasons being shown to the court of law may condone the delay in filing the WS or written statement. As such, the expiry after the expiry of the WS, after the expiry of the filing, after the expiry of the filing or the expiry of the period as stipulated under the law, the defendant may be given an opportunity to file its written statement on sufficient reasons being shown to the court of law. Now, what does this written statement must contain? There are following particular which must be mentioned in the plaint itself. Number one, that as the written statement is the reply to the plaint, therefore, if the defendant wants to deny any facts as stated in the plaint by the plaintiff, then he is under obligation as per Rule Order 8, Rule 5 CPC, whereby he is under obligation to deny the each and every fact to be specifically denied and not evasively denied. In case if he evasively denies a particular fact as mentioned in the plaint, then it would be treated as an admission on his part with regard to that particular fact. Furthermore, at this point of time, I would like to draw your attention to the Evidence Act. As you all are aware that admission has been defined under section 17 of Code of Civil Procedure. So we may say that that there is an interplay between the Indian Evidence Act and Code of Civil Procedure on this point. Furthermore, if a particular fact which has been admitted by the defendant, then the plaintiff may, on the pleadings of the defendant may file an application for judgment on admission, and the court may, after looking into the averments of both the parties in this regard, can pronounce judgment in favor of the plaintiff. Now, next point, is it necessary for the defendant to file all documents along with the plaintiff? Answer is yes. As per Order 8 CPC, defendant is bound to produce all the documents in support of his defense. Can the defendant also file some other remedy or some other via media by which he can also claim certain amount from the plaintiff in the suit filed of the plaintiff? Answer is yes. This remedy to counter the defendant is known as the plea of set off and counterclaim, which has been mentioned under Order 8, Rule 6 and Order 8, Rule 6A of the Code of Civil Procedure, respectively. No pleadings other than by way of defense to a set off or counterclaim can be filed. So from this, we may infer that apart from set off or counterclaim, no other pleading can be filed by the defendant. Next. Is there any leading case on the point? Answer is yes. In the case of Balraj Saneja versus Sunil Madan, AIR 1999, Supreme Court 3381, wherein the Supreme Court has held that in case, especially where written statement has not been filed by the defendant, the court should be little cautious in proceedings under Order 8 Rule 10. What is this Order 8 Rule 10? Order 8 Rule 10 provides that in case the defendant has failed to file its written statement within the stipulated period, then in that particular circumstance, the court may pronounce a judgment against him. So, at this stage, in this particular case, the court holds that before pronouncing the judgment, court must take the cautious approach. What is the reason? The reason is simple, that hasty decisions may lead to fallacy. As such, the plaintiff must prove its case beyond reasonable doubt, or he must fulfill his obligation as contemplated under the Indian Evidence Act and thereby satisfy the requirement of Section 101 and 102 of the Indian Evidence Act. Now, next important concept which we have to read in this is the doctrine of set-off. What do you mean by doctrine of set-off? Doctrine of set-off is a claim set up against another. It is a cross-claim which partly offsets the original claim. Furthermore, it is an extinction of debt of which two persons are reciprocally debtors to one another by the credits of which they are reciprocally creditors to one another. This doctrine has been explained in the following words as, where in a suit for recovery of money by the plaintiff, the defendant finds that he has also a claim of some amount against the plaintiff, then he can claim set off in respect of the said amount. Further, a plea of set off is a plea whereby defendant acknowledges the justice of plaintiff's demand but set up another demand of his own to counterbalance that of the plaintiff, either in whole or in part. Now I will give you an illustration over here. A sues B on a bill of exchange for rupees 500. B holds a judgment against A for rupees 1000. The two claims, being both definite pecuniary demands, may be set off against each other. Now, what are the conditions to be satisfied for putting the case of set off before the court of law? So, following are the conditions. Number one, the suit must be for the recovery of money. Second, the sum of money must be a certain sum of money. Such sum must be legally recoverable. It must be recoverable by the defendant or by all the defendants. Furthermore, it must not exceed the pecuniary jurisdiction of the court in which the suit is brought. Both the parties must fill in the defendant's claim to set off the same character as they fill in the plaintiff's suits. Next, what would be the effect of set off? When a defendant pleads set off, he is put in a position of the plaintiff as regards the amount claimed by him. So there are two suits, one by the plaintiff against the defendant and other by the defendant against the plaintiff. And both may be tried together. Next, if plaintiff fails to get relief in his suit for any reason whatsoever, it does not affect the claim for set off by the defendant, and a decree may be passed in favor of the defendant if he is able to prove his claim. So from this, we may infer that plaintiff's suits would not affect the set off or counterclaim filed by the defendant, or the same would not be affected by its dismissal. So, this is all about today's lecture. Hope you all have enjoyed this lecture and also learned from it. In case you have any queries, then you may please write to me at my email ID, that is rahularora.gn@jagannath.org. Before parting with the today's lecture, I would like to apprise you with my new topic, which I am going to take in my next lecture. And the topic which I am going to deal in my next lecture is that of counterclaim, wherein I would like to explain you the rules regarding the counterclaim as contemplated in under Order 8, Rule 6A, CPC, and also distinguishing the same with the concept of set off as given under the Code of Civil Procedure. Thank you very much. We'll meet you soon.